I know that one of the things that you want to see is a restraining order bill, so explain to me what that is.
Well, if you habitually assault somebody, or you rape them, or you cause criminal damage to their property, the moment all a judge can do is sentence you to either community service or imprisonment or a fine. But what he cannot do is prohibit you, the defendant, from going near that particular person. Now, the whole purpose of the restraining order bill is to allow a judge to also say you're not allowed to contact that person. And we have had plenty of examples of, say, women who've been viciously assaulted by men or by ex-lovers who've survived. The man's gone to prison, and he's come out of prison, and then he's stood on her doorstep, waited for her, and then that's ended up in rape or murder. Now, as soon as that man had gone on her doorstep, if he'd been in breach of restraining order, the victim could have called the police and he could have been arrested for breach of that order, and you wouldn't have to prove anything else. And I think it's vital that we have a restraining order bill, and most of the judges that I've talked to would welcome having a restraining order provisions as part of their sentencing powers. The moment the position is that we can restrain people from going on football matches, we can ban people from driving, obviously, and we can restrain people, but only under the Harassment Act. And I think we've got to have a restraining order across the criminal jurisdiction to stop infatuated behaviour that is aggressive and is causing a lot of women a lot of problems.
What's the difference between that and taking out an injunction against somebody? For instance, if Sarah Lockett's stalker now goes anywhere near her, she only has to pick up the phone and the police arrive.
Well, you see, Sarah Lockett's stalker has been restrained from coming near her under the Harassment Act, and I'm saying that restraining order has to apply across the board, because a lot of infatuated behaviour ends up in sentencing other than harassment. And the silly thing is that if you're being stalked, you might not be able to prove the stalking, but you can prove, for instance, criminal damage of your car, someone breaking a window of your house, particularly if it's seen, or you can prove an assault, or even malicious telephone calls. Now, you can prove the malicious telephone calls, but it might not amount in law to harassment. Now, what I'm saying is that a malicious phone call, contrary to the Telecommunications Act, should bring in bind to restraining order to stop them from telephoning.
Brilliant, that's great. That's what I just wanted to try, because I think people would think, oh, I don't quite understand. The other thing is, presumably now, though, you can take out an injunction against somebody, can't you?
Yes, so you can take out a civil injunction, and obviously if they breach that, then they can be taken before the civil courts for contempt of court. But the great problem with civil injunctions is there isn't a power of arrest, and no one can be arrested for breaching one except under the Harassment Act. Now, the great difficulty is if you might not have an injunction under the Harassment Act. You might, in a particular case, get an injunction under nuisance or under property laws. And if the person breaches it, they can breach it, stand outside your house, act in defiance of the court order, and they can't be arrested. And I think, again, the restraining order provisions would help with that. And I think we've also got to have major changes in our injunctive and contempt of law procedures, because it makes it hideously expensive. Someone goes to civil court, they have to pay for it or get legal aid. They have to instruct a private detective to serve the person with a sealed court order. They've got to go to court first, get an order, come back, serve to the person, and then the person has to voluntarily go to court. And it's only when he hasn't been to court on one or two occasions that he's then arrested and brought to court. It's a hideously expensive procedure, and it costs a lot of money, and it can cost, £7,000, £8,000, £10,000. That's why people don't take out civil injunctions in these sort of cases.
Is it easy to get legal aid to deal with a case like this?
Well, of course, we have a government here which is making obtaining legal aid much more difficult than before. And I think that a lot of these cases of stalking and infatuated behaviour, I take the view that they are public order offences, and I would like to see a situation where people were given non-means tested legal aid to assist in these kind of cases, just as they do when children are in difficulty, or in asylum cases people get non-means tested legal aid. It's vital that we get it, because we are undermining democracy in this country by not giving people effective court remedies.